जल आपूर्ति 34/2018 तक, और आज तक नहीं हुई है। आज तो नर्मदा ही सूखी है, तो 90 हॉर्स पावर के इनटेक वेल्स में गाद भर रही है पानी के बदले। देन भवन निर्माण के लिए पानी आपूर्ति, वो तो कभी मिला ही नहीं, लोगों को परचेस करना पड़ रहा है। तो गरीबों ने कहीं सारे घर बांधे नहीं है, आज टिन शेड्स में सैकड़ों लोग पड़े हैं। तो ये सभी चीजें पीछे हैं, ये अभी हम ज्यादा समय नहीं रुक सकते हैं। सो दिस हैज टू बी टेकन वेरी एवरीथिंग, यू नो, द हलाव पशुपालकों के लिए चरागाह नहीं है, कई बोर्ड्स लगा के रखे हैं, बट द ग्रेजिंग लैंड इज नॉट अलॉटेड। स्मशान घाट नहीं है, रास्ते नहीं बने हैं।
Before I used to hear your argument as these juniors are hearing it.
जबलपुर is too far away now for me.
नहीं, मैं उस समय आपका आर्गुमेंट ऐसे ही सुनता था जैसे सब जूनियर आए हैं यहाँ से।
Your Lordship, obliged.
Yes, madam.
This is related to resettlement and rehabilitation of Sardar Sarovar ousties. After 38 years of struggle, I have to again come back to this court, and it's a public interest litigation because it is a question related to thousands of families.
Still, after so many years, they have not been rehabilitated.
I mean, much has happened and much has not yet happened. Because
much
in spite of
flowed.
all the authorities, the Narmada Water Dispute Tribunal Award, the state level liberalized policy is somewhat liberalized, which the judgment in our case of 2000, I'll give you a few pages of provisions which include land to the eligible landholders who lose more than 25% of their land.
Yes.
Then the house plots and the civic amenities which are listed in the tribunal award. And what has happened is that the civic amenities was to be provided at the rehabilitation village. So actually a community was to be rehabilitated as community, and obviously the agricultural land and the house plots and the civic amenities should have been at one place. That has not happened, especially in Madhya Pradesh. But still 83 sites exist today. Earlier it was 88. But then they had to cancel 5 sites because there were a number of problems related to those sites. Now the point is, Your Lordship, that kindly see P1, page 7, where the Narmada Water Dispute Tribunal Award, which is a decree, as I said, which is also established through the 2000 judgment.
Yes.
It is said in the clause 422 that Madhya Pradesh and Maharashtra shall set up adequate establishments for land acquisition, rehabilitation of hostage families, etc. And it says that 1 year before submergence, land was to be allotted, and at least 6 months before submergence, the rehabilitation should have been completed, and then the notice should have been issued for the family to shift to the resettlement site. This has not happened at all, and this is proved through number of reports. Actually, even the World Bank withdrew from this project, which was opposed by Maharashtra and Madhya Pradesh for 10 full years when the tribunal was sitting. We were not in the picture at all. But then the tribunal gave its award, and the provisions were somewhat better, but there were a number of gaps. For example, the landless were not thought about. Adivasi was not even mentioned in the tribunal's 5 volumes, because the tribunal visited only 3 temples, not one house or a community of the affected family. And it is, however, stated in the tribunal award. Kindly have a look at page 10, Your Lordship. Clause 462 in the same P1. In no event shall any areas in Madhya Pradesh and Maharashtra be submerged under the Sardar Sarovar unless all payment of compensation, expenses and costs as aforesaid is made for acquisition of land and properties, and arrangements are made for the rehabilitation of the hosties therefrom.
This starts from page 20.
No, now I am talking about the page 8 of the petition itself.
Page 8 of memo petition.
Yes, yes. But there I have quoted the tribunal amount.
Okay.
What is mentioned in...
This is the only work which was allotted to them.
No,
there
in
there is
our-
no other work. They can debut.
No, there are 7,000 applications pending before GRA. So how can and when will they visit the sites and how will have the technical expertise? And that's why, Your Lordship, this the same Supreme Court case which
Yes.
I mentioned, what it has mentioned is very important. It is only where there has been a failure on the part of any authority in acting according to law or in non-action or acting in violation of the law that the court has stepped in the case of PIL. No directions are issued which are in conflict with any legal provisions, but directions have in appropriate cases been given where the law is silent and inaction would result in violation of the fundamental rights or other legal provisions. Now this is exactly the case. It is under Article 21. Nothing less than right to life and livelihood for the people who have lost for nothing because no benefit to the state and thousands of crores have spent. But that apart, what I am saying is that when GRA was given this task by the Supreme Court through its order, my lord, P5, page 220, just have a look at para 11 of that order, and then with that order, when the GRA was given the task, in spite of that, GRA just passed an order in which there was one paragraph which is on page 244,
Yes.
and para 20 on page 244 of this thing, which just said that जहां तक विस्थापित कृषकों को विस्थापन स्थल पर मूलभूत सुविधा प्रदान करने का प्रश्न है, आयुक्त नर्मदा घाटी विकास प्राधिकरण को निर्देशित किया जाता है कि सभी पुनर्वास स्थल पर सक्षम अधिकारी द्वारा निरीक्षण करवाया जाकर मूलभूत सुविधाओं में से जो भी कमी हो 2 माह की अवधि में इसकी पूर्ति करवाई जाकर पालन प्रतिवेदन इस प्राधिकरण के समक्ष प्रस्तुत करें। अभी करोड़ों रुपयों का काम ये 2 महीने में तो होना संभव नहीं था। उसके ऊपर फिर जस्ट उसके बाद का ही आप देखेंगे लॉर्डशिप P8 we wrote to the GRA and we also had to have a sit-in in front of the GRA office.
That was in 2017.
17.
And thereafter they
Yes.
passed the order of P2.
Then they passed this order of 2811.
On
Now-
your representation, now government has again appointed a GRA to
Yes.
look into the grievance.
But your lordship,
And,
the
in
work is not a short time work.
petition you have not declared that you have an alternate remedy, and yes, the details of remedy.
The
exhausted.
alternative
This is
remedy
the remedy
is-
available to.
We want compliance.
This GRA is for you or not for others. So why?
But GRA is
let
not
the
existing.
GRA function. We don't want to.
And no, your lordship, there has to be a technical inquiry also, because if
We are
they,
here to examine their award. Let them pass an award, then we will consider.
but GRA is not functioning, your lordship.
Now it will
So-
function. Now appointment has been done.
No,
We will
out of
start-
5, only 2, and those
It's a
2 have
matter
not
of-
accepted according to our information. Your lordship, I will give you some photographs which are
And
colored.
we will dispose of with direction to GRA to function.
But
We'll
within
direct government
within
to
the
provide
time
our
limits.
facility. That's
Your lordship, they had given time limits, and if you see the
एक समय लगा
report,
जब तक ना हो जाए ग्रहण करने के दिनांक से एक बार
there was a
प्रकरणों के निराकरण-
full-fledged, your lordship, there was full-fledged 7 years long inquiry, which was under Commission of Inquiries Act according to the NVDA, but in fact the High Court had appointed it, and no action has been taken, irrespective of the inquiry, thorough detailed inquiry done by the Manit, Maulana Azad Institute and IIT Mumbai, to which retired Justice Zah Commission had given the task as outsourced, because it was a fully technical report. And if there is annexed part of that report, which is P4, if I'm permitted, I can read some of the paragraphs, but you would be shocked to read the summary of the conclusions.
That was in 2014.
So it is not the job which can easily be taken up by GRA, your lordship. So there has to be a full-fledged inquiry with the technical experts and involvement of the resettled families, representatives, and there has to also be a time-bound, action plan, which needs to be monitored by this honorable court. Otherwise, year and year has passed, and today, when they are at 5 kilometers away from the Narmada, they have no water in many places. Tankers are also not reaching, so on and so forth. And the schools are not, there are no health centers. There is a special mention in the 2000, this thing, that health centers must be run in everything. The bhavans are built, but there is no doctor, there is no nurse. Once a while they visit for vaccination or something, and that's all. So it is so shocking that after having spent crores of rupees, Article 21 is violated, and there is no one to monitor this. There are no rehabilitation officers in place now. All the task is given to SDMs, who say that we have no time. Now they will all be busy in the elections, They were busy with the vaccinations till now. So
Yes.
who will look into this? We really very humbly request this honorable court to
Yes,
keep up the monitoring task in its own hands. So
We'll come to
please issue writ of mandamus,
Yes, Mr.
but
President.
also please.
As rightly pointed out, in page number 278, madam, that is the order of 28/11/2017, madam. Earlier also the GRA in paragraph number 20 has directed the authorities to submit the complaints.
270.
244, madam. Page number 244, para number 20, madam.
Yes.
And the members' appointment has already been done by the state government
Yes.
in last.
There is no one appointed to look into this task.
Madam, I will consider.
There is no rehabilitation officer in place,
We'll
your lordship.
examine your.
When thousands
application and
are
all.
awaiting rehabilitation. And if you kindly have one page ahead, 279 onwards, and every single aspect had a time-bound direction given.